Last year, a number of states throughout the United States passed laws that very aggressively limited abortion. Alabama's law more or less completely outlawed abortion. States like Louisiana, Ohio, and Georgia passed laws which were so-called heartbeat laws. These were laws that purported to ban abortion at the point when fetal heartbeat can be detected. What is the status of those laws? I think a lot of Americans heard about those things happening, were happy that they happened, but don't really understand how they work, given on-the-record Supreme Court decisions like Roe v. Wade and Planned Parenthood versus Casey. Well, the short answer is that these laws are not effective. They are not in effect, that is. Basically, as soon as they were passed, federal courts put injunctions against them, saying these laws cannot be enforced because they contradict various Supreme Court decisions which are purporting to interpret the Constitution. The theory is that a normal law passed by a state legislature cannot contradict a relevant portion of the U.S. Constitution, or at the very least, what the Supreme Court says the Constitution means. But that doesn't mean those laws were useless. On the contrary, I think these laws and their passage was very important. These laws have to be litigated in the courts, and the claims that are being made by these states that pass these laws is this: we believe that these laws are constitutional. We believe that the Supreme Court decisions of Roe v. Wade and Planned Parenthood versus Casey were wrongly decided. And we passed these laws because we want to challenge Roe v. Wade and Planned Parenthood versus Casey and force the Supreme Court to rethink its abortion jurisprudence. And eventually, that will happen once enough of these states pass laws to outlaw abortion or to limit abortion and to challenge the status quo of Planned Parenthood versus Casey and Roe v. Wade. This will present an opportunity for the Supreme Court to re-examine its old decisions. This is part of the process that we pro-lifers have been working towards ever since Roe v. Wade was passed in 1973. We needed to get conservative justices on the Supreme Court who would be willing to rethink Roe, and then we needed state governments to pass laws that directly contradicted Roe v. Wade so that we could have a new legal challenge and allow the court to revisit its thinking in Roe v. Wade and Planned Parenthood versus Casey. With that Right to Life thought, I'm John Gerardi from Right to Life of Central California.